When I wrote it as an internal document for me and my paralegals because I didn't write it how we did it. I wrote it how I thought it should be done, that we weren't doing it. So it was aspirational in scope. I wanted to be able to do it the way that I could picture it in my mind, but because we never had really had it written down, sometimes we would deviate from the plan. So I actually wrote the entire thing and then just circulated it to my paralegals and said, let's try to go with this plan. And it now gave me a document that I could edit, that if we were doing something and it really didn't pan out, then we could go back and revisit it.
So I'm super excited to have Sam Elder with us today. Sam and I have known each other since high school, and that's been like 35 years now. And I wanted to introduce you to Mallory, who's my co-host. Mallory works at Parks and R with us. She graduated Stanford Law School, which is top 3 law school in the nation. And she was a public defender to start out with. And then now she handles intake for us. And in particular, I mean, all the personal injury cases, but in particular, she's handling our medical malpractice intakes, which are, as you know, the most difficult ones to kind of sift through to decide whether or not it's a good case. And she's even going a little bit further and vetting some expert doctors to see whether or not the case is viable or not. So Mellor is a huge part of our firm. Sam, I know that after high school, you went to Linfield College, did mathematics and science or physics?
Philosophy.
Philosophy, that's right. Okay, mathematics and philosophy. Great college. And then went on to University of Washington Law School, which is a top law school as well. You started in some corporate law and then ultimately ended up in personal injury, which we're going to want to hear about. And then you currently practice in Issaquah. You have a lean and mean personal injury practice, intentionally smaller, and you are involved in pretty much all your cases from beginning to end. You do your own arbitrations and trials. And I know you have somebody else with you as well, but you are involved in all your cases, which is awesome. You're also a leader, a thought leader, and a leader under in our field, personal injury, the Washington State Association for Justice. I know that you're active and have been active for a long time. Some of the things that you're best known for, I mean, Tencer, who is an expert we're going to get onto that story, but other experts as well, as well as the Washington Arbitration Handbook, which I think is just awesome. We give it to all our young attorneys, but young or older attorneys, they can all learn from that, and we're going to want to hear a lot about that. And then recently you did one of the best presentations at Wasage that got a lot of talk, kind of about the future of law and AI and everything else. So we're going to want to hear some about that. One of our missions for this podcast is to help younger lawyers kind of find their way, help educate them, help give them a little bit of direction and some maybe personal lessons from your own experience, and potentially even kids that are going through law school or even thinking about going into the law. I mean, it's a changing field, and like to navigate through that and to kind of give proper advice is a tough thing to do, but let's talk through that as well. But I wanted to start with what got you into personal injury, because you were in corporate law before and then you kind of switched over to personal injury.
Yeah. Well, first of all, thanks for the introduction. Hi, Mallory. Yeah, I did in law school. I took mainly like tax and business planning and stuff like that for classes. But I was also very interested in healthcare law and personal injury kind of in law school. When I came out, I was just working as an associate. The guy that I was working for, Wes Edmonds, he did mainly business and corporate stuff, but he had a tiny little personal injury practice. And my experience was at the end of all the corporate cases, the clients were always pissed off. They spent too much money. They probably picked a fight of their own making, spent too much money on it, and then were disappointed. Whereas on the personal injury cases, I mean, my clients were happy. They would send me cookies, balloons, flowers. They would thank me. I got cards from people saying I changed their life. And that just stuck with me. I was like, the corporate stuff just never made my heart sing. Working for injured people actually made me feel good at the end of the day. So I was like, I took that very tiny practice, just a few cases, and I just built that into my entire practice.
And were you good at it from the beginning? Because I know you're really good at it now, but at the beginning, were you good at it as well?
I would say I did a lot of reinventing the wheel early on. Like I didn't have a lot of forms, a lot of infrastructure, a lot of examples to go off of. So I just started like making it up as I went. I did go to a lot of CLEs and tried to learn stuff. But I did a lot of internal tracking on myself early on to figure out like, hey, is what I'm doing working? And I've always had a little bit of a mad scientist inside of me. So I would just experiment and I would say, well, I'm going to do it this way this time and see how it goes. I'm going to do it this way this time and see how that goes. And I did really track myself very carefully. I mean, one of the things that I credit as a great thing in my career was because I did a lot of corporate stuff early on, I kept track of all my time. And so I tracked that and I started looking at the efficiencies of these cases, like, and trying to discern the patterns that I saw in them. Like, where is it that I'm actually doing well on these cases and where am I spending like inordinate amounts of time and getting paid very little? And that's definitely part of the reason that I ended up doing personal injury cases too, is because I realized, hey, I can make it doing this work. Um, I figured out ways to be efficient. I figured out ways to be effective. And it just felt like, I mean, everything lined up. I was happy and I was kicking ass and taking names. So,
Yeah. Well, and that's a different approach than a lot of personal injury lawyers because the whole data approach and the scientific method behind lawyering is not typical of most of the other lawyers out there because I mean you still have data from way back then. So you have like years and years, decades of data, right?
yeah, I mean, to be fair, I don't really look at it anymore, but I have done this numerous times during my career where at the very beginning, I remember I literally had a spreadsheet of every case that I worked on, how much the medical bills were, how much the wage loss were, description of it, what the offers were, what the final result was, what the insurance company was, and I just tracked it all so that I could see like, okay, these insurance companies are paying me, these ones are not, these cases are working out, those ones are not. But then that same thing, I mean, I've probably done that in my career like at least 4 or 5 different times where, for example, I went back, I did a big analysis on cases that I ran through civil arbitrations. I looked at 100 cases and the results, and I was trying to discern like, hey, what was the best offer before I filed the lawsuit? What was the ultimate result? And how successful am I? And it turns out it's about 98%. About 1% is a tie, and about 1% is a loss. And about 98% of the time but of course it should be that way because I mean, if it was a good offer, I would have taken it. But when they're giving me an offer that, in my opinion, is too low, I'm right about 98% of the time. And I'm a tie 1%, a loss 1%. So,
And so just to give context, that means if you decide to take a case to arbitration and you're looking at their highest and best offer, and let's say their highest and best offer is 35,000. What you're saying is out of all the times you've gone to arbitration, 98% of the time you are getting better than that 35,000 as an award.
yes. And that's been consistently true throughout my career. But again, I don't want to make myself look like I'm doing better than I should have because if the 35 was a pretty good offer, I took it. It was
Yeah.
only in the case where I thought the case was worth 50, 60, 70,000. And most of the time I'm right.
Yeah. And so how many arbitrations do you think that's been that you're at this 98%?
I mean, I think that the number is probably over 400. I've lost track at this point, but
Well, how
yeah,
many arbitrations do you do a month now, even now?
well, I mean, there's a difference between how many we file and how many I actually arbitrate. I think my record, we used to keep track of how many I did in a year, and I think I did 25 in a year. So that's
Yeah,
about
so two a
a
month.
little over two a month. but those are actual hearings. The number that I've filed in a year would be considerably more. It's probably, up around maybe like 40 a year,
And
something
so
like
it's
that.
sometimes you'll get a better offer after you file for arbitration, and you'll end up taking that prior to going into arbitration, right?
Sure. I mean, I've had cases where literally they offer, like the civil arbitration limits are 100. I've had them offer me 100.
Yeah.
So I'm like, how am I going to say no to that?
Yeah.
You know?
So part of the skill then is like being accurate in your valuations.
Yeah, and I should suggest one other thing, which is, and this is truly mad scientist type stuff. Um, there were years ago, I heard a lot of people were talking about how insurance companies consistently de novo appeal from arbitrations, and I knew from my own experience that that wasn't true, but I didn't have hard data to back it up. I only knew my own experience, so I actually went to the arbitration department of a couple counties and just asked them if they could share their data with me. And I told them, and it was true that I was going to like teach some classes and write an article about it. And like a couple counties just coughed it up, like years of data. I actually had at one point 6 years of every case that went through King County Superior Court that was assigned to arbitration in a tort motor vehicle context. So, I mean, that was like thousands of cases that I analyzed. I like hired a high school student during the summer to like pull dockets and help me analyze all the stuff. But I just had so much data to go off of at that point. It was amazing. I mean, at that point, I knew which arbitrators gave good awards, which arbitrators gave poor awards. I knew what the ranges were. I knew how often the de novo appeals were. I analyzed which insurance companies appealed at what rates. And I mean, it was like having the key to the kingdom at that
You were
point. That
like your
I've,
own little AI, your own little
well, I mean,
custom GPT.
it's funny because in those days we didn't think of it that way. We thought of it, I thought of it as it used to be called data mining. I was just a data miner and I would go get all of this information. And, I credit that with a lot of my success because I wasn't going into the situation blind. I really knew, what the variables were. And, if I knew that I had an arbitrator that was, pretty tough, I would then spend more effort trying to settle the case. If I knew that I had a good case with a good arbitrator, then why bother settling? Um, yeah, so I do feel like, I'm very data driven in the work that I do, and I've spent a lot of time trying to make sure that I've got the best possible information to go on.
Sam, I
Yeah.
have a question about that might help new lawyers who are just starting out in PI. First, thank you so much for being here. I'm really excited to learn from you. I've heard a lot about you from Rick. But I'm curious how much, like, if you could estimate a percentage of how much time you spent as an early lawyer, early PI attorney, on data, like data analyzing data specifically, and what would you recommend for new attorneys in terms of how much time they should spend doing that analysis? Because it sounds like it really helped you in gaining confidence in your own judgment and what to focus on in your practice.
Yeah, I did spend a lot of time doing it. I think nobody asked me to do it. No one suggested that I should be doing it. And in fact, I did a lot of this just completely on my own when I didn't even, I was just an employee there. But I started running all the data on the cases that my old boss, Wes, and I were working on. And we started like, I went to him and said, hey, I think we ought to restructure our fee agreements. I don't think that we're getting paid on some of these cases. And here's why. And I showed him the data and he was like, wow, I would have never looked at it this way. But and that was the thing is I did take a lot of classes on business planning and tax and stuff like that. I got a degree in math. I like numbers. So yeah, I spent a fair amount of time on that. And I mean, honestly, think about it. When I was a young lawyer, how valuable was I as a lawyer? Not all that much. How valuable was I in figuring these things out? That was probably more of a benefit to my firm than anything else. So I just tried to look for opportunities that I could, pick up an oar and start rowing the boat in the right direction. And that turns out as a young lawyer, that was probably like more valuable than my legal skills. Now, over time, I think I got better and, started pitching in more, but, that's what I could contribute. So you asked about specifically like how much time I spent. I don't know. It's all in the margins. I just spent a few minutes here and a few minutes there, and I just made a spreadsheet. And when I'd settle a case, I'd put it on there. I was tracking time anywhere, so I would put it on there. I mean, it didn't feel like much, but it's one of those things. If I had waited and tried to recreate it like years later, oh, that would have been really, really difficult. But if I just did it contemporaneously along the way, which I did, I never really noticed the time that I spent on it. It seemed to me that if anything, it was more just like, record keeping of what I was doing. And then, a few years later, I look back and it's like, wow, I've got a good log here. I can actually use this and do something with it.
You had mentioned that you rarely get appealed when you go into arbitration, but what did the data say for everybody else?
Well, to be fair, the data's kind of old. And I think the data actually got better for plaintiff lawyers since I did it. I want to say that the initial 3-year period that I analyzed was 2010 to 2012. And then I think I did 13, 14, and 15 again, just kind of spot checking to make sure that the data looked the same. But I think it worked out that roughly a third of the cases were being de novo appealed. And
But
so
yours weren't though.
no, no. I mean, I got them pretty rarely. And I think it's a combination of factors. I think that back in the early days, I probably got a bit more, but then have a really good record on de novo appeals. I think after some of the companies, paid me a number of times fees on de novo appeals where I got an award of attorney's fees, I think they started rethinking. I'm pretty sure the insurance companies track my performance just like they track everything else. So they track me, I track them, and it's all fair. But yeah, and I would tell them a lot too that hey guys, I have a really good record on these things. You might want to go fight with somebody else. And I think at times they listened. So there were cases that they would de novo appeal and then just withdraw it. And but I think over time, then I noticed, especially, limits went up from 50 to 100. That made a difference. Also, COVID and the way that we started doing them over Zoom and stuff, like a lot of the dynamics changed. And I think that the appeal rates actually fell. And as well as, I mean, I always credit Mike Maxwell for this, but he lobbied really hard to make sure that the defendants had to actually sign the request for trial de novo. And that reduced the number of trial de novos that were taken as well. I mean, the fees went up as well. So there's a number of factors that I think discouraged de novo appeals. And my belief from all of my analysis and, the analysis that I did actually ended up being used in the legislature when they decided to lift the limits from 50 to 100 is that the system was working incredibly well. I mean, the judges know it. The most of the lawyers know it. That it's an efficient and effective way of resolving these claims. And I think some of the insurance companies, they don't like having to pay these, but they also look at it and go, "Hey, playing double or nothing, triple or nothing on these appeals, they got to be careful." I mean, if I were in their shoes, I would probably still do it against lawyers who are fakers that aren't really going to go try the cases. But for the lawyers who are actually going to pay attention and try the cases and do a good job, it's a sucker's bet. Why would they de novo appeal, except in the most egregious cases?
So I got an example that recently came up in our firm, and one of the young lawyers, he had a good arbitration award, and then they appealed, and then we were kind of in midst of a discussion of what to do on that. The defense lawyer was trying to get a hold of him, and then the question was, do you just wait until the 20 days pass, or do you try to negotiate it? So what are your thoughts on that for young lawyers, just in general? I mean, they're always a case by case basis to some extent, but in general, what would you say?
Well, in general, I mean, if they're just threatening to appeal, I mean, I would call their bluff and see if they actually do it. Um, it also funds the court system. They have to pay, like, I forget what it is, like $400 to appeal. Make them put their money where their mouth is. It's easy to just say that they're going to appeal. It's a different thing to pay the money, get their client to sign the form, meet the formal requirements of doing the appeal. So I generally don't talk to them during that period of time. I mean, within reason. I mean, if they make an offer, I'll share it with the client. If they make an offer that's really good, I'd probably take it. But I don't go out of my way to negotiate before they appeal. my opinion, and I don't know, maybe this video will be used against me, but their bargaining position doesn't really change whether they file the appeal or they haven't filed the appeal yet. So why do it before? Just wait until the appeal and then talk to them if you're going to talk to them. That's kind of my approach.
And then let's say they do appeal. How much do you dig your heels in, even though you're like, well, that's probably somewhere where I think I could get at trial, but how far do you dig your heels in and just say, I'm going to start like I'm going to show the insurance company that, they shouldn't appeal my cases. Is that important?
Yeah, I mean, it all depends on the facts of the case. And if I've got a winner, then yeah, my inclination is just to damn the torpedoes full speed ahead. I'll just go spend the money that I need to, spend the time that I need to, get the experts lined up, prepare to win the case. And I give a lot of credit, by the way, to Raphael Urquia out in Port Townsend. I mean, he and I have taught a couple classes on this, and I've really learned a lot from him. I mean, he has a great formula for how to win these cases. You outlay witness them, you out expert witness them. A lot of the insurance companies think that they can put on the same case they put on at the arbitration and win at trial with it. And, I think Raphael's plan and that I've adopted in my practice is we don't put on anything close to the same case that we put on at the arbitration when we get to trial. We're way better. I mean, as it should be, right? The arbitration is an attempt to, in a cost-effective and kind of condensed way, a couple-hour hearing and you get a result. If it's going to be a jury trial, I'm going to load for bear. I'm going to win, I'm going to spend the money necessary because that's the thing is if you do a good job and you beat the offer compromise or arbitration result, then you get all the money back and more. So,
Yeah, you get
you
your
know, it,
attorney's fees.
yeah, you get the attorney's fees, you get the expert witness costs, you get the litigation costs. I mean, it's like, why not do that? And I mean, obviously, you and I, Rick, we did a case together that was a de novo appeal. And as long as you make it work out, um, it just paid its dividends all over. I mean, it's
Yeah.
beneficial for the client. It's beneficial for our reputation. It sort of sends a message to the insurance company like, hey, guys, you want to appeal these things, it's going to hurt. And so maintaining a really good record on de novo appeals is important. That being said, if the case is weak, I have to recognize that. And
Yeah.
it's not as if I'm a magician. I don't get to turn a bad case into a good case simply because I want to. So I have to be grounded in reality. And if the case, but I think one of the key differences, lawyers can't allow themselves to just be afraid. You got to be able to step back and take an honest look at this. Like, am I going to be able to win this case or not? And be honest about my skills, about the witnesses in the case, about the opposition that we're going to be facing. I can't just drink the Kool-Aid and think that I'm going to be great all the time and win. If I did that, I'm sure I would lose more cases. But I really do. If the case is weak, I will make a real attempt to settle it. And I do. And another thing is after a de novo appeal with the offer of compromise statute, we have an enormous range of flexibility in our negotiations because I mean, and insurance companies already know this about me, so I'm going to go ahead and say it, and I'm not letting the cat out of the bag, is you can do more than one offer of compromise. So like if I arbitrate the case and get 100, I might come in really early afterwards and say 95. And if they take it, great. If they don't take it, I might say 90. And then I might say 85, but they don't know how many times I'm going to do that. Maybe I stop at 90 and I never go down again. Maybe I keep going all the way down to 20. They don't know. And so anyway, we've got a lot of flexibility. At any time, I can just say enough is enough. I'm going to damn the torpedoes full speed ahead. And so anyway, we've got a lot of advantages. And because it's a one-sided attorney's fee provision, where if I end up short of the number that I need to beat, it's not like I have to pay their fees. But if I end up over the threshold, they have to pay mine. I mean, it's just such a I don't know why they would appeal. It just seems like all the cards are stacked against them. That is not a scenario that they're going to do well in. And I mean, as it should be, they should only be appealing the ones that are really egregious. And if they are egregious, well, then the deck is stacked against me, maybe. But and then the key is being honest about the difference. Is this a case where I've got them or they've got me?
Yeah, no, that's all great stuff. And so with the you were mentioning the offer of compromise, and what that essentially is so if you get that $100,000 award and you make an offer of compromise of 80,000 and they don't accept it, then at trial all you need to do is beat the 80. You don't need to beat the 100,000 anymore. You just need to beat the 80 to get your attorney's fees. And as we know, I mean, sometimes these attorney's fees, they're over 100,000 in addition to the fee that you normally get based on your award. So like in that example, you get $100,000 arbitration award. You make they appeal it. You make an offer of compromise for $80,000, and then you go to trial. And let's say you get a $120,000 award. Not only are you getting the attorney fee on the 120,000, which is a contingency fee, but in addition to that, you're getting your hourly rate from the time that they appealed until post trial. You're getting your hourly rate for all of that, and sometimes that could be over $100,000, which is significant for maybe a smaller case. And even more significant is like, let's say the award was $20,000
Yeah.
and they appeal, and you make an offer a compromise, because that was one of the situations I had. I think the arbitration award was $25,000. We ultimately make an offer a compromise for 10,000 because it was a tough case. And they appealed the 25,000. They did not take the offer compromise for 10,000. And this was like over 10 years ago. We got 11,000 on one passenger and 9,000 on the other. And so we got attorney's fees on that, and it was, like 120 grand in attorney's fees. So even on a small case, the the risk is pretty high.
Yeah, I think insurance companies are just banking on lawyers not being willing to take the case to trial. I mean, they just um, I think that and I mean, I don't mean to pick on our colleagues, but there's some people that won't take them to trial. And hey, if I was in the insurance company's shoes and I knew the other side never takes them to trial, why why compromise? So you got to hold their feet to the fire. That's the only way that you're going to get them to be reasonable, is to back it up. And you don't need to hit 100%. Honestly, I think if a lawyer just took a bunch of these cases to trial and lost them all, you'd still be better than someone who doesn't take them to trial, because at least they know you're going to take them to trial and they can put in the defense costs as part of their attempts to resolve the case. But if you have a decent record, and I mean, I've got a really good record against these guys, they have to take that into account and recognize that this is not going to be fruitful for them.
Yeah, and even if you don't have a good record, if you keep taking them to trial, one of them is going to go. One of
Yeah,
them is going to punish them really bad. You never know when it comes. I mean, if
Well,
you're
and as a
trying,
new attorney, I imagine as a new attorney taking cases to trial, even if you lose, you're getting experience and getting better and better as you go. So not only do they then learn that you're going to continue to take cases to trial, but you're also
yeah.
gaining experience and hopefully getting better as you do more.
Absolutely, Mallory. And I mean, you look at, there's another way to think about this. Like, I develop a lot of my best materials in the context of de novo appeals. Like, I spend a lot of time going after expert witnesses and deposing those expert witnesses and really getting deep into their background and their bias and so forth. What better time to do it? Because as long as the case ends up well at the end, all of that time and energy is going to be paid for by the defense. So it's like they're paying me to take down their experts. And then I use those materials later in cases that are not de novo appeals. So it's it's really the gift that keeps on giving. I mean, you get a ton of experience, you get a ton of good materials, you write the best motions, and it's an opportunity to really be a good lawyer on those cases, because if you can file 12 motions, you file all 12 motions. Just go ahead and do it. And then you got great materials going forward. You get the best relief. You set up your client with the best odds of winning. I mean, why not do it?
Yeah,
Yeah.
Sam, that leads me to another question that I had. So you're talking a lot about sort of, cases that are appealed versus not. And I'm curious how your strategy differs. You were just talking about how you sometimes use materials that you've developed preparing for trial later in cases that don't get appealed. So I'm curious how you strategize differently for an arbitration versus a case that's going to trial, and how you determine whether you're going to develop new materials versus using stuff you already have.
Yeah. No, it's kind of interesting thinking about my evolution, because at the very beginning of my career, I didn't put any cases through arbitration for, like, I think about the first 5 years of my practice. Every time that a confirmation of joinder or statement of arbitrability came up, I just checked the box of like, it's over the threshold no matter what. Because I mean, that's the thing. I just didn't know any better. And I didn't ever use the system. And then once I started using it, I realized like, hey, this actually works pretty well. And I remember pretty early in the process, after I'd done a few cases, but not a ton, maybe I'd arbitrated like 5 cases, I sat down one day and I made a spreadsheet and I said, what is every activity that I have to do to actually get a case to an arbitration? And I wrote down every activity that I could think of, whether I did it or my paralegal did it. And then I assigned time values to each one. And I sort of, figured out the bottom line. Like, how well do I have to do on these cases to make it pencil out to where I can actually make money on them? And then, we internally started thinking like, okay, let's just make a really efficient procedure. Because in my mind, the framework was, look, you've got the option of taking the best offer that the insurance company is going to make, or you could have a neutral third party decide what the number is. And I mean, just thinking about it structurally, like, who's going to offer you more? The person who actually has to write a check out of their account, or some random neutral person that it's not their money? I mean, you're just going to get a better result consistently out of somebody other than the enemy. I mean, why would they value the case as much as that? Now, it's not 100%. Like I said, I do occasionally get losses, but most of the time it works out pretty well. But I think that that's a lot of it. The strategy, frankly, is just to change the forum. Do I want to be talking to the insurance company and the adjuster and taking whatever pennies they're willing to throw at me? Or do I want to move it to a hearing before a neutral person? And then my strategy is, it's don't overcomplicate things. Some cases are complicated and you just can't avoid it. But, an arbitration, you basically have 2 components. You have a written submission, and then you have a presentation of witnesses and argument in person. And my old partner, Randy Gordon, I give him a lot of credit for stuff. He came up with the analogy. He said, it's kind of like figure skating. You get 2 scores in the Olympics. You get one for technical merit and you get one for artistic impression. The technical merit is the written submission. The artistic impression is having your clients tell their story and making good arguments. And I love doing arbitrations because, it's not high pressure. It's not high stress. I've done at this point hundreds of them. My heart rate never goes above 70 when I'm doing them. And I do a good professional job. I prep the clients in advance. I mean, to be fair, my paralegals are fantastic. They know how to put together good materials. The time and energy that we spend just basically shifting the forum from a demand letter to an insurance company to an arbitration hearing in front of an arbitrator, like, we make that transition seamlessly and efficiently. So it's almost like, if you've never done it before, it feels like climbing Mount Everest. But after you've done it 400 times, it feels like, standing up when you're sitting down. It's no big deal. It's just not a big deal. And so I just started doing them all the time. Like, why not? Like, if I like the offer and I think it's fair and good, I'll take it. And if not, why bother talking to them? Just switch forms and go, so, and in a lot of cases, I just get one offer and I'm like, nah, they missed it. They if they make a good offer and it's in the ballpark, sure, let's keep talking. But they only get one chance to make a bad offer. And then I'm just like, I just file. And a lot of times they'll call me and they'll say, hey, we saw that you filed this. What's up? And I'd be like, well, I believed that you believed your offer.
Yeah.
I took you at your word. You said you thought it was worth 10,000. That's not even close. I'm just going to go win. And, I could get off on this subject a little bit too, but I think a lot of people rattle their sabers talking about bad faith and how insurance companies are bad. Insurance companies, in my opinion, they're not afraid of that. What they're afraid of is someone who just will go win, someone who
Yeah.
doesn't bullshit them, someone who's just going to say, no, go beat me. Randy and I used to talk about it when we're litigating cases. It's like someone just handed us the football and we just run as fast as we can towards the goal line. And anytime that we're looking behind us to see who's going to try and tackle us, we're not running as fast as we can run. So just grab the ball and run, and then let them stop you, and let them make the good arguments. And I think sometimes people get too worried about the warts on their case. And my experience, having done hundreds of these things, a lot of times the defense misses their arguments. They miss the good argument, or they send a lawyer who just didn't they have one lawyer answer the complaint, another lawyer who does the deposition, another one writes the pre-hearing statement, and a fourth one shows up to do the arbitration, and they just drop the baton somewhere in there, so they don't even make the good argument at the end of the day. That's where, like, on my side, my team, we pass the baton. Like, we successfully hand it off, so when we get there, we do a good presentation and usually goes our way. That's not to say that I can overcome, really bad deficit or defects in cases. I can't sometimes, and I do lose them, and I have to put that into my evaluation. But don't just assume the worst all the time. Like, what about assuming the best? Like, maybe it goes well for us. It could go against us, but why am I going to, like, stack the deck against myself? Like, I might as well at least see if it'll go well.
Right.
I don't
Yeah,
know
and
if that
that
answers
part
the
of that,
question, but that's
yeah, part of that's the fear factor, right? I mean,
That's what I was thinking. Yeah.
yeah, you fear of losing, you fear of being embarrassed, you fear of, having to, put yourself out there. So,
Well, and it sounds like I want to go back to one thing you said, Sam. It sounds like it all really does come back to tracking yourself, especially as an early attorney, because what you said earlier was you tracked how much time you were spending on different aspects of these cases and found what worked and made it more efficient. And I imagine that's important. Even getting advice from somebody like you, every attorney is going to have different strengths and weaknesses. So if you're able to, as a young attorney, track where you're spending your time and where you're most successful, that would really, really help you with that confidence and sort of avoiding that fear, because you can track and see what your results actually are and then trust that this is going to pay off.
well, and I do think I've missed one point that I did consistently that's super important, which is you have to go do a little bit of a postmortem afterwards. If it went well, figure out why it went well. If it went against you, figure out why it went against you. And then, always refine, always make a better mousetrap. Always try to refine your procedure to make it a little bit better. If you're finding like, oh, yeah, I should have addressed that pre-existing condition a little bit better, well, put it in your game plan and make it better next time. We're not perfect, but if you do the same thing over and over again and make tiny adjustments, even if you're just making tiny little incremental improvements over time, your operation becomes really good based on that feedback.
and
So
is that why
that's
you put together the Washington Arbitration Handbook?
it's funny because when I wrote that, I did not write it as to how my office did it. I didn't. I wrote it as an internal document for me and my paralegals because I didn't write it how we did it. I wrote it how I thought it should be done, that we weren't doing it. So it was aspirational in scope. I wanted to be able to do it the way that I could picture it in my mind, but because we never had really had it written down, sometimes we would deviate from the plan. So I actually wrote the entire thing and then just circulated it to my paralegals and said, let's try to go with this plan. And it now gave me a document that I could edit, that if we were doing something and it really didn't pan out, then we could go back and revisit it. Now, in my office at the time, we shared space with a number of lawyers, and I gave it to a couple of them to see if they had more ideas. And they said, Sam, this is great. You should, like, teach classes on it and stuff. And I did end up teaching classes with a few edits to it. But I think I first wrote it in like 2007 or 2008. And then I started teaching classes on it in 2008. And it's gone through multiple revisions as things have changed, strategies dropped out, new ones came in, limits went up, and so forth. But yeah, I think, it's funny too, because some of the stuff that I had in there were ideas. I mean, I'm not going to take credit for it. A lot of them were Randy's ideas too, Randy Gordon. And I thought up this plan, but we included stuff in there that nobody did at the time, back in 2008. Like, for example, right after you get a notice of appearance, just drop a ER 904 / MAR 5.3D or CAR 5.3D disclosure on them, like the first day. Nobody did it that way, when I recommended that. But if you look at how the practice works now, 17 years later, I would say a lot of lawyers do it that way now. And so it's kind of cool looking back that, like, just the fact that I wrote it down, I like actually moved the needle and I actually changed the way that things happen in the state of Washington. I think that there's a lot of people who use that as a reference guide. And so it's kind of cool. But
Oh yeah,
I just
our
think,
office uses it. Angel, my partner, she gives it to every young lawyer who comes into the office. She gives your older version. Now that I know that you have the updated version, we're going to want to. And where do people get that? Where do people find that?
well, it's on uh, Washington State Association for Justice, the CLE materials that are on there. Or you can email me, sam@samelderlaw.com, and I'm happy to share it. But yeah, I remember early in the process being worried, like, what if an insurance company gets a hold of my playbook? Like, are they going to use this against me? But at this point, I'm sure they've all got it.
Yeah,
They know too. But it's not a secret. It's just, and there's nothing weird about it. It's just how to do this efficiently, effectively. And I don't really even care that they know what I'm doing. But it is more like, okay, that's what I'm doing. Now stop me.
yeah.
Or
What about what I was gonna say for young lawyers, how should they be using that if they read it? Like, should they read it all the way through, or should they just look at certain sections?
well, I designed it to be kind of a guide. In fact, the name of it is the Guide to Civil Arbitration. And I've done a few of these guides over the years. I did a guide to district court because there was a brief period that district court limits went up, but civil arbitration limits were still low. So I was trying cases in district court. I did a whole guide to district court. I've done I never called it a guide, but I've kind of done like a guide to experts, and just kind of explaining my process that I go through in preparing for experts. But that's the thing, is that's how I like it. It's supposed to be kind of paint by numbers, like first do this, second do that, third do this. And the Guide to Civil Arbitration, it's laid out from like, these are the considerations you should think about before you even file. Here's the stuff that you do when you initially file. Here's what you do when the defense counsel appears. Here's what you do when they answer, and so forth. And it just walks through every step along the way. I think that's how I like to organize my thoughts, is just like a paint by number, a recipe book, which, if I can tell a little aside, it's funny because Randy and I, we worked on this, the one of the cases that really shaped my professional career, and it happened pretty early on. I was only 5 years in, and Randy and I tried this 10-week long jury trial against three huge corporations. They had like 30 lawyers against us. It was 2 against 30. And I credit that case. We ultimately lost the case. We tried the case to a jury, it got defense verdict on the case. But I think it shaped a lot of my career because it was almost like, I mean, we called 100 witnesses. It was 10 weeks long. There were about 3,000 exhibits in the case. It was a mammoth case, but it was almost like I just went to the gym and I pumped iron for like a year. And then every other case that I picked up was like picking up a gallon of milk. It was just not that big a deal. Or if things were scary, they were never as scary as that case. The lawyers we were up against were like top notch, really good lawyers. They spent like, I don't know, like $30 million defending the case or something like that. I mean, Randy and I joked it would have been cheaper just to kill us than, than to do it, because no one else would have been crazy enough to go try that case if we were out of the picture. But, I look back at it and it was like a fourth year of law school for me. This was like in the courtroom every day. I mean, I carried these big bags to and from the courtroom to the point that like by the end of the trial, my chest was like muscular. I was carrying like heavy bags every day up and down the hills of Seattle. And but that's it. Law school was great, but being in the courtroom against really good lawyers and watching that all come down. I mean, that was literally my first jury trial, was a 10-week long
Oh,
trial
wow.
with like all these witnesses and stuff. But Randy and I, in the course of doing that, we had to innovate and come up with new ideas, because if we were not on our toes, we would have been absolutely crushed by the number of lawyers on the other side and the number of briefs that were being filed and motions that were being filed and everything. But coming out of that case, we had all these new tools. And part of the way that we thought about it is the defense in a lot of personal injury cases was defending it like a recipe book. They were defending it like preheat oven to 350, get out a large mixing bowl and do this. They were doing the same thing in the same order. And they would always do certain things at the very end. Like they would always do a CR35 exam, like right before the discovery cutoff and stuff. And so one day when Randy and I were talking, we were like, well, what happens if we just flip the script on them? Like all the stuff that they want to do at the end of the case, we press at the beginning of the case. And all the stuff that they want to do early on, we just kind of like muddy the waters on those and push those towards the end. What would happen? And it turns out that it would completely get people off of their out of their comfort zone, and we started getting really good results when we did that. So that's still a lot of the plan that we do. Like, why do I do the ER 904/CAR 5.3D disclosure at the very beginning of the case? That all came out of the flight attendant case that we had worked on, that big 10-week long trial. Like all of these innovations that we came up with, they say like necessity is the mother of inventions. That was the mother of all cases. Like that gave birth to all of these ideas that incorporated themselves into my practice for, all the last couple decades after.
Yeah, what a great experience. I want to go back to arbitrations real quick before
Yeah.
we end that topic, but what's your philosophy on like how many witnesses do you call? Like, do you just call the plaintiff, or do you try to get some lay witnesses? Do you try to get some experts in there? And like what length of time? I know some people, they go into arbitration half hour. Some people, treat arbitration a little bit more, more like a trial. Where do you fall in how intense or how much effort do you put into the arbitration?
Yeah, I obviously it depends on the case, and the value of the case and the issues in the case. But as a general rule, first of all, we always have a doctor declaration supporting the medical treatment in the case. I would never go to an arbitration without that. And there's a number of positions that, hopefully the treating doctors, if not bringing in a forensic expert, but you got to do that. If you don't do that, you deserve to lose at that point. Um, there are a couple exceptions where the claims are minor and they're just one thing like scarring from the case without really injury or something. Like you can imagine a case that it's not really disputed, but you almost always have that. So that's the starting point. The second point is we do like to get written declarations from lay witnesses. For example, bosses, HR departments, stuff like that about wage loss. Even from clients on wage loss, like there's no reason you can't do a declaration from the client on their wage loss and put them on as a witness still. I really like that because you don't want them fumbling all the numbers on direct testimony, oral testimony at the arbitration. So just lay all the technical stuff in a declaration from the client, and then have the client just during the course of the testimony say, yeah, I did that thing because I didn't want to screw up the math, but that's all accurate. And that's all they need to say. And then in terms of having other witnesses testify live, I think it just depends, like, are they good witnesses? Because, a lot of times I'll talk to them or my paralegals will talk to them. And if they're unimpressed, it's a declaration. If they're really good, then we want them testifying live. In terms of the duration, I've always said, and I trained James Prescott, my associate, I kind of trained him this way too. Don't be afraid just to ask the arbitrator at the beginning, like, how much do you want to hear? Like you do, because sometimes they'll tell you. I remember I had an arbitrator once. He said, look, I've been doing this for over 30 years. I've read all the materials. I think I already know how I'm going to rule. So if you guys want to say something, go for it. But like, don't feel like you have to. Listen to it. That arbitration, I went for like 10 minutes with my client because he clearly didn't want to hear it. Other cases, you've got somebody that's the arbitrator that doesn't even really do this line of work. So you're going to have to spoon feed them more and kind of give them a full presentation. So, and a lot of it depends on the issues. I mean, if you have something like a pre-existing condition that was aggravated, you probably want to spend more time on that. And if you don't, you're doing so at your own peril. So in a case like that, or sometimes I'll have cases with multiple collisions or multiple injurious events. And if you've got that, like you better spend some time on that if you want to win. So I think the range is as short as 10 minutes, and a long one, I might go 4 hours in the right case if the issues are complex enough. And I'm concerned that if I don't spend that time, I might lose.
Awesome. Thank you. And let's move to Tensor real quick, because Tensor is, I mean, when I first got out of law school, my first couple of trials, Tensor was the defense expert on those cases. And that's for cases with like minimal visual property damage. And, Tensor just killed me in those cases. And it was unfair. It was unfair for the clients to have to go, have an expert like that who essentially says, if there's no visible impact to the vehicle, it's more likely than not that there was no injury. And he goes through all this scientific stuff that makes you believe that that's true, which we know as plaintiffs' lawyers, that's not true. But how did you deal with him?
Well, first of all, I had heard all about him and I had seen a couple of his reports, but I had never really faced him until I hit this case in, I think it was like 2011, 2012 time period, um, maybe 2010, somewhere in there. And I just decided, I literally at that point in my career, I said, hey, I've come up with a lot of good ideas and I feel good about a lot of areas of my game. But I was like, the one thing I'm terrible at is experts. Like, I don't have a clue. I felt very deferential towards experts. Like, I was kind of afraid to go up against them. And then I had this case with Tensor, and I just decided, a lot of people have faced him, and he is like the scourge of plaintiff lawyers. And so I just decided, like, I'm going to see if I can figure out what makes him tick. So I just set aside the money to do this. I deposed him for like 8 hours one day. And I actually didn't finish. And so I came back like later and deposed him a second day. And I read all of his papers, and I think I deposed him for about 12 hours in that case, and just tried to figure out, like, how does this guy tick? And it's funny because I remember after the very first one, afterwards he looked at me and he said, wow, I'm really impressed. Like, so few lawyers actually take the time to read my papers or understand. Like, he was like very friendly, very nice towards me. And even now, I think the guy, he knows exactly what he's doing, but like, if he wasn't doing his job and I wasn't doing my job, I might actually get along with the guy pretty well. Seemed like a nice human being at some level. But what he's doing, I don't appreciate, because I think he knows better. I think he knows that people get hurt in car accidents, and his suggestion that they don't is at best misleading. And so anyway, but I guess the takeaway is, the first time I faced him, that's the only trial de novo of my own case that I've ever had not beat the threshold for triggering attorney's fees. And I wasn't happy about it. I don't take losses very well. So, I mean, when I finished, I was like, dang, he got the better of me in that case. But I just started thinking, it's not over. It's not over. That's just chapter one. And so I went out on the WSAJ listserv and I just asked, hey, anyone else have cases with him? I'm interested in deposing him. And I just kind of made a commitment on that day. I was like, I will face this guy anytime, anywhere, any place, whether I'm getting paid or not paid. I'm just going to stick with him until I figure out how he beat me. And so I deposed him in a second case, and then a third case. And then I think a fourth case, maybe. And then I ended up in a hearing in front of a judge deciding whether he could testify. And that was the day that everything broke loose in my mind, because I remember I was asking him all these questions, and I had a big box full of documents from the transcripts of all these other cases that I had deposed him, and I flagged every question. And it was tricky because I would ask him sometimes, deposition 1, he would evade, deposition 2, he would evade, deposition 3, he answered it. And then on another question, he evaded it in 1, answered it in 2, and didn't again in 3. And then another question, he would answer it in 1, but not 2 or 3. So I had to piece all this stuff together like an elaborate puzzle. But I started asking him the questions, and he was just dodging and weaving. And I remember the judge took a break. It was Judge Hickman down in Tacoma. And he took a break, and he pulled down his glasses. He looked at Tencer, and he said, Dr. Tencer, I'm going to be making a decision as to whether you get to testify in this case. So when we come back from this break, you might try answering some questions. And then we took the break and we came back, and what happened afterwards? Pure gold, because he knew I'm going to be done unless I answer the question straight. So for the first time, he answered all the questions straight. And I didn't have to use my elaborate puzzle to force answers out of him anymore. It went way quicker, and I got all the transcript with a good set of answers on things that I could really go after him on. And then I continued to develop that over years, but I faced him a lot of times. I developed a motion to exclude him. And eventually the case Gilmore versus Jefferson Transit, which was based on my original motion to dismiss that was filed by Sunshine Bradshaw, but that made it all the way up to the Washington Supreme Court. And we got a favorable ruling saying that the court can exclude Tencer if the judge determines that he's not helpful to the jury.
Yeah, that was a huge moment in the plaintiff's bar because really, we stopped taking the low visible property damage cases to some extent because they were so hard and the insurance companies would offer so little. And so it wasn't really worth it for us to take those cases until, you were able to get Tencer excluded, and then you created kind of a playbook in getting him excluded. That was really helpful for all the plaintiffs' firms, I believe.
Well, maybe I'm kind of crazy, but I remember like Randy came to me after years of doing this, and he said, Sam, you're doing so well. You should only work on like $1 million cases. And I remember telling him, like, no, dude, like someone needs to get good at these cases. Like, this is where people need help. Like, I mean, I hate to say it, but lots of lawyers can go do the clear liability paralysis case and get policy limits. But who's going to take the low impact case with very little property damage where someone's hurt and find justice for these people? I was like, if I don't do it, I'm worried no one will do it. So I just kind of stuck with, I don't mean to be like the hero or the martyr, but like, honestly, I was like, somebody good has to do this stuff and just press it until we can prove what I knew to be true. These people couldn't be faking it. They couldn't be wrong. They were hurt in these car accidents, and I just had to figure out a way to expose that. So, I mean, the lesson I took from it, I lost the first time. I kind of lost the second time or the third time too. Like, it took a number of times, but if you just stick with it long enough, you can eventually figure it out. And I think that extrapolates to most experts. The first time that you face them, you're probably going down. They're smart. They know their field. They're very good. It might take you. Now, one of the advantages is if you do piggyback on other people's work, maybe the first time you go after them is really the fourth time that someone's going after them, and you can make use of other materials. But I think it's very important, if you're going to go after an expert, stick with them. Like, I think too many lawyers, they face the expert, then the case settles or it goes to trial, and they just forget about it. And they don't save their materials. They don't share their materials. They don't give feedback to other people on how it went, what strategies worked, what strategies didn't work. And that's the technology that we as plaintiff lawyers need to share with each other. We have to share the materials because, I mean, these people are smart. They're going to get me too. I mean, I have experience dealing with it, a lot of the defense experts now, but if I don't have materials, like, I'm just not that good. I need some ammo to be able to use against them. And that oftentimes comes from people sharing.
So you were recently a presenter at the Washington State Association for Justice conference, yearly conference. And, everything I hear, You were engaging, you gave a ton of great information, and everybody loved it. So what are some of the things you talked about there that you think the listeners could benefit from?
Well, I think there's two main things. One of them is you need to stick with the experts long enough to kind of figure out who they are. And I kind of categorized it in four categories of experts, which I would say number one is the true believer. The true believer is like a chiropractor who doesn't believe in chiropractic, or a doctor who really thinks people don't get hurt in car accidents, or they think everyone gets better in 6 weeks. Like, they're not lying. They believe it. They truly believe that people are not hurt and that they're just making it up for money or whatever. So knowing that is important. The second type is what I call the hired gun. And these are people that literally, if the plaintiff lawyer hires them, they'll tell the plaintiff side of the story. If the defense hires them, they'll tell the defense side. In fact, I have a funny story, a well-known, mostly defense lawyer. He said, Sam, if you hire me, I tell your side of the story. If the defense hires me, I tell their side of the story. And I said, what about just telling the truth? He just laughed at me. He just laughed. He said, there is no truth. It's just like spin. That's all there is in the world, is like you could tell it either way. It's like, okay, but knowing that you've got the hired gun, if that's who it is important. The third type I call the charlatan. And the charlatan is just someone who goes well outside their lane. So this is like the MD who starts being an expert on billing rates in, somewhere, or you get the CPA who's talking about that he knows what the billing rates are, or it's like the MD who just does like knee surgeries, but starts giving psychological diagnoses of the patient. Like people that are they're pretending to be someone who they're not. And then the fourth category is kind of old school, but it's the umpire. And the umpire is just called balls and strikes. If they see someone that they think is hurt, they'll say they're hurt. If they see someone that they think is faking it, they'll say, I think they're faking it. Those people I have respect for because they're entitled to their opinion, and they will call balls and strikes. That's fine in my book. But you don't know that if you're just facing them once. You probably got to face them 2, 3, 4, 5 times to really get, and probably most people don't fit 100% into a category. They're probably a blend. But knowing that's important. So that's the first.
What's the benefit of knowing that?
Well, I mean, you can try and frame people with things that fit. But if you're trying to suggest that someone is a hired gun when they're really an umpire, it ain't going to work. Yeah. If you're trying to claim that someone is paint them as a true believer, but they're really an umpire, that's not going to work. Or even a hired gun. It's a different mindset. It's a different strategy. And I think understanding a little bit about how they tick is important. Because, and that's the thing, is there's lots of different strategies. And I talked about some of them, and you got to find one that kind of fits.
Yeah.
So the second thing that I explained is just my methodology of how I go about going after experts. And it's sort of, I think it's 6 steps. Let's see if I can get them. But the first one is, I call it casting the net. So you just basically assemble as much materials as you can, put on the listserv, go on the Eagle Exchange, get all of the depositions, all the reports, all of the financial information, go on the internet, do searches, figure out everything you can figure out about the experts, download their papers and all that stuff. That's one. 2, you got to read all this stuff. And this process I call 3 days of hell, because it usually takes me about 3 days to sit there and digest and do the next steps. But you got to read through it and kind of make some notes. Then the third step is I kind of organize it into chapters and, lines of attack that I might end up using. And I start by kind of laying them all out. And then once I've got them all, I go through the fourth process, which is a lot of editing, because some of the things that I want to use, they're just not going to pan out in the end. So I kind of separate the wheat from the chaff, the good lines from the bad lines, and start to develop into a comprehensive program of like, this is what I'm going to try to use. The fifth stage is you got to put it in boxes. And this is more like what I was talking about, that I had a box with like everything tabbed out and copies and, put it into SharePoint and do all this stuff. But you want to be super, super tightly organized. And there's a reason, which is the next step. Because once you get this box all organized and you've got an outline divided into chapters, you've got all of your source material all tabbed and ready to go for trial, the last step is the most important one. You take the box and you put the lid on it and you put it away. because no matter how much time and energy you've spent on it, and no matter how excited you are to spring some of these traps on them, you got to stop and listen to their direct testimony at trial. Because a lot of times the stuff that they say at trial is gold. And if you're thinking about what you're going to say next and what's going to be in your box, you're not going to catch it. You're going to let it go right by you. So, and the whole point of having that all organized in a box is that you can free up your mind to just listen. And in cases I have had where I don't use a single thing in my box, even though I spent 3 days of hell putting it all together, I heard something better on the stand and I just went with that. So you know, and of course, if you don't get anything new, you've got the box, but it's all ready to go. But that's my 6-point strategy.
Oh,
That's how
that's
I take
awesome.
them down.
You know, one of the things I'm learning here today is that it's not enough to be smart. I mean, you have put some real hard work into, being a great lawyer.
I do.
Yeah.
Yeah, I was just going to say, I think that I've done a good job of recognizing where I'm no good and then just going, I need to get better there. And it's simple. And I mean, it's simple. It's a slow process of little bit of improvement over time. And a good example is, when you're a young lawyer, you read the deposition transcript and you're all excited because you just killed this witness, and you get back the transcript and it's all filled with ums and hus, and your the transcript doesn't look as good as what you like, or sometimes you think you nailed them, but then you go back and you look at it later and actually they kind of give themselves an out. And so you develop an ear for this over time, that you get really good at knowing, like, I just got them, I didn't. And you read the transcript 29 years in, you don't have many ums or hus left. How did that happen? It just happened from recognizing, like, that's a deficit. I need to get a little bit better. I need to get a little bit better. And then you do it for 29 years. Not saying that I'm a completed work, because I'm constantly finding stuff that I'm like, why am I doing that? That's stupid. I need to get better. And then you do. That's the process.
Sam, I wanted to say, I think it to me, I'm hearing that it comes back to the fear element. Like, it sounds like not only are you not afraid to try new things, go to trial, test out these things, but you're also not afraid to look at yourself and look at your flaws and lean into those to get better, which I think a lot of new attorneys can learn from.
Yeah,
Oh,
I think
yeah.
I think you have to be honest with yourself too. Like, there's no shame in being bad at something. There's shame in being bad and not getting better. Like,
Yeah,
everyone starts off no good. I mean, how
right.
would you be good? Like, I was a new lawyer. Like, I give myself a little bit of grace. Like, I had never done this before. It's not like my dad was a lawyer and my grandpa was a lawyer and I came from a long string of lawyers and I grew up in a courtroom. Not at all. I remember, like, I didn't even know when I got to the first day of law school, it said, like, plaintiff. I had no idea what it was talking about. Like, who's that? Like, I didn't watch court TV stuff or Law and Order or anything. None of it. I had no idea. So I started at absolute zero.
Yeah, and the other great thing is when you start to learn and then you put it together, then you share it with the rest of the plaintiff's bar. So you're not you don't hold those things that you learn close to your chest because you're, greedy, or you feel like, oh, if I share this, then I won't be able to take advantage of the things that I learn, and everybody else is going to learn it. And so, I mean, that's very gracious.
Well, thank you. It's also the recognition. Most of the things that I use, I didn't come up with myself anyway. I heard them from somebody else. I think the only thing that I can take credit for, I mean, a tiny bit of stuff I came up with on my own. Mostly what I did was I listened to other people. And when I heard something that I liked, I wrote it down, or I kept track of it and I incorporated it into my game plan. But that's why I always feel good about sharing, is because it's a way that I pay back for the fact that lots of people gave me the information that I'm relying on. I think another thing that underpins our practice is it's not like I consider other firms to be my competition. I mean, there's an enormous pool of humans that need our help, and there's not enough of us to go around. There really isn't. There's people that don't get any justice whatsoever. So, like, improving the state of the art technology for being a good plaintiff lawyer doesn't result in other people beating me in any sense. It's not like a zero-sum game. It just results in all of us helping people more effectively.
Yeah, Sam, I think I really respect and admire the fact that what I've heard from you today is that you really care about these clients. The reason you got into personal injury in the first place is because you appreciated that these clients actually need help and are so appreciative of the help they get because they really need it. And you are so willing to provide that. And it sounds like that passion for helping people is part of what makes you such a passionate advocate for these people and so willing to look at yourself and get better at what you do.
Yeah, it is definitely part of what I love. And it's not unusual that I go well outside my lane when I talk to clients, because I'll tell people all the time, like, hey, you're hurt right now. You're going to need to rely on friends and family. And it's one of the most difficult things that we do in society is have to ask for help. But you're going to have to ask for help. Like, you're hurt right now. And people don't get that. But I'll share stories with them, because the truth is, when I have a friend who asks me for help, I don't feel put out. I feel like I'm honored by the fact that they trust me enough to help them during a time of need. And it actually creates intimacy and bonding for people. So, and it's the same thing. Like, I've been through hard times in my life, and I've called friends and said, man, I am down on my luck. Like, I need help. They don't tell me get lost. They like feel awesome. Like, yeah, what do you need? What can I do? So I encourage people to do that, or just telling people like, hey, your body's in a remodeling project right now. Eat right. You know, your tissues can be made out of Burger King, or it can be made out of like healthy food. Eat healthy food. Like, you're hurt, man. You got to take care of. And I've had people say, Sam, how is it that I've seen 10 doctors and not one of them ever said any of this stuff to me? And I'm like, I don't know. It's not my business to tell people what to do, but I think that they do appreciate the fact that, you know, I want them to get better. I even tell clients, like, I want to keep your claim as small as I possibly can. And they're like, what do you mean? And I'm like, because I want you to be well. I want this to like pass you by. Nothing would make me happier than if your claim is very small and I get very little money and you get very little money. It's because it didn't mess up your life. And I do think that there's a natural differential between what people lost and what someone else will value it for. Like, it's always more painful to experience it yourself than what a judge, jury, arbitrator, adjuster, anyone else is ever going to assign to it. So if you're hurt a lot, the differential is more. If you're hurt a little bit, that differential is less important. So that's always our job number one, is to get people better. And I don't know. I have my view. I'm kind of old school. If you gave me $1 for diagnostics or $1 for treatment, I'd spend the dollar on treatment, not on diagnostics. So like, making a case worth a lot of money because you ran them all over town and figured out 100 things that are wrong with them versus just get them better. You know, I pick get them better.
Yeah.
That's just my philosophy.
No, that's great. Let's talk a little bit about AI and the future of law, because that's a big topic right now.
Yeah.
What do you think? What do you think about AI and how it's affecting the law, you know, the law industry and, you know, the profession?
Yeah, I mean, I've had several blow my mind moments with AI over time. I mean, the very first time that I started using ChatGPT 3, and fortunately, I'm blessed with, I have a good friend from high school that he lives in Switzerland, but he was getting a master's in computer science right around this time. So he started talking to me about LLMs, and I was like, I had no idea what he was even talking about. And he sent me a page of gibberish that was made up by ChatGPT 2, and it didn't make any sense to me at the time. Like, why do you even send that to me? But then he tuned me in when ChatGPT 3 came out, and I started messing with it. And yeah, I was just amazed. Like, this is such a great tool. But it's a great tool, but with some limitations. And so I do think that it's going to totally transform the practice of law. But I think it's both more and less powerful than what people expect. And my belief is that a lot of lawyers want the AI to be like a little elf or fairy that comes in the middle of the night and does all the work for them. And I was trying to think, where did that come from? And there's an old Brothers Grimm fairy tale called The Elves and the Shoemaker, I think, where the shoemaker lays out some leather, and then these elves come in the middle of the night and make these fancy shoes. And he was like going broke, but all of a sudden his business does really well because the elves are helping with all. I think that's what lawyers want, is they want these elves that'll go do their work. But I'm kind of reminded that story, like the shoemaker had to lay out the leather, and the elves weren't running the store. They weren't selling the shoes. They only did the middle. And the truth is that's what AI is. It's good at the middle. You still have to prompt it at the beginning, and you still have to check all the stuff at the end. But the middle part, it's starting to be helpful. Now, maybe over the years, it will get to the point where it can do the beginning and it can do the end. But right now, it's terrible at the beginning and it's terrible at the end. And it has some utility in the middle. I've been benchmarking AI, and I've been trying to see, like, when is it getting good enough that I can actually put it into production? And for the most part, the benchmarks that I've been using, which is a series of paralegal and lawyer activities, it's been failing it. It's just not there. Like, I'll give you an example because I just had one for the first time ever. It passed one of my easiest benchmarks, which was there's a large version of it, but the benchmark version is it's 30 Walgreens prescription receipts that are out of date order. And I feed it to it and I give it 2 prompts. Number 1, make a downloadable file that put these in date order. And number 2, make a spreadsheet that shows the date and the charge for each bill. When I fed that, this is an experiment that I did, I believe, last week. And last week, when I gave it to ChatGPT 5, it said, I put it in order, boss. And when I looked at it, the first 15 pages were in order and the last 15 pages were not in order. So it was like, lied to me. Nice try. When it made the spreadsheet, first of all, it only had 25 entries. There were 30 pages. So I'm like, okay, I know you failed already, but then I kind of audited it and saw how it failed. And yeah, certain pages, it just, skipped. I gave the exact same project to ChatGPT 5 Pro agent. It succeeded on both accords. It put all 30 in correct order. It made a spreadsheet that hit all 30. Every amount was right. Every date was right. It hit it. So, I mean, that gives you an idea. And I use it as a bit of a comparison. If I gave that to elementary school students, could they have done it? Probably not the first graders, but I'm thinking by 6th grade or 5th grade, something like that, they probably could do the same work. Junior high, I'm pretty confident most of the kids could be doing what I'm doing, just taking 30 pieces of paper and putting them in date order. I mean, that's not rocket science, but I think that's where it's at for the middle. It's performing at about somewhere around elementary school age, maybe junior high level. And if you're expecting it to do more than that, you might be disappointed.
Yeah.
That being said, yeah.
Well, we use it in like for example, if you're about to take a deposition of somebody, and you want to quickly organize your thoughts, and you could just spit out like a bunch of information, and then it will organize it in a way that is very clear that maybe you couldn't come up with that quickly. Like, maybe you can come up with an outline that was clear in 2 hours of work, but it'll spit it out in 2 minutes. And then in addition to that, it will come up with some things that you hadn't even thought of. So, it's beneficial in that situation, but you still need to know your case. You still need to know how to prompt it. And then, like you said, you still need to review what the AI spit out to see whether or not it's accurate. But you can continue to iterate.
Yeah, don't get me wrong. I mean, AI is beautiful on a lot of fronts. It's fantastic for brainstorming. It's fantastic for taking something that I wrote and writing it better. It's fantastic for taking, like, for example, a response to a motion that I wrote and just brainstorming other ideas or other cases, or maybe give me some additional cases to read and I read them and end up incorporating them. It could be good in a lot of ways. And I've used it personally. Like, a good example, I find myself saying the same thing to clients over and over and over again on certain topics. So I listed out 55 different topics that I'm constantly saying over and over again. And I used AI to help me write scripts for each one of those, explaining that topic. It helped me make slide decks for every one of those topics. And then I used AI to basically synthesize my voice. So it's Sam explaining those 55 topics to clients. And then I also could go back and make me speak Spanish. I could make me speak Korean. I could make me speak Chinese, Mandarin. So it's fantastic for stuff like that. It's got a lot of great uses. In fact, the number one place that I find myself using it, it's great for me to just dictate stuff and end up creating really good notes of the thoughts that I have. So like I do it with my staff. We're talking about a particular topic and nobody has to write it down. We just end up with a fantastic summary that hits all the key points. That's great. Sometimes I do it when I'm talking with clients or talking with witnesses, get it to summarize information so that I don't have the keyboard interrupting the flow of connection that I have with the witness or with the client. So it's great and for a lot of different things. But I think it's not the elves that come in and do the lawyer work or the paralegal work at night. It's just not there yet.
Yeah. Well, and so like what I think is that for those firms and those individual lawyers that don't leverage AI and don't learn how to interact with it, and then versus the ones that utilize it heavily and leverage it and learn about it, there's going to be a divergence. And the people who really know how to work with AI and take advantage of it versus the people who don't, there's going to be a huge gap. And it's not there now, but as it gets better and as you get better utilizing it versus the people who don't, who are like, I'm against AI or AI can never, be as smart as humans, that gap is going to widen. And I think it's going to widen in the next 2 to 5 years.
I agree 100%. And I think this is why I do a lot of my benchmarking is because I want to know what it's good at and what it's not, so that as it gets better over time, and it has gotten so much better, even a lot of the benchmarking that I did like months ago, it's no longer relevant. I mean, it gets better month after month. And I also encourage people, think about how it can assist you in the rest of your life, the non-law part of your life, because if you free up the rest of your life goes a little bit easier, maybe you have more energy for practicing law. So everything from, making healthy recipes, sleeping better at night, like any question that you have, you get answers right away. And just having that Einstein level, or trivia master level information that's sitting in your pocket all the time can just make the rest of your life go smoothly. And then you have more energy for taking on projects, for doing, the next great thing.
Yeah, and what I'm
Oh, go ahead. Sorry.
I was just I just want to say what I'm hearing from as you and Sam are talking, Rick, is it sounds like there's two ends of the spectrum with AI. There's not using it at all and assuming that it's not going to help you at all, which is going to leave you behind. And then there's also using it too much and relying too heavily on it, which can actually hurt you by giving you false information that you're then relying on for your practice. So there's that sweet spot in the middle where you want to use it and leverage it in a smart way, in a way that's, taking into account the deficiencies and the ways that it's not as accurate.
Yeah, for sure. And some of my benchmarks, I just keep on running over and over again. Like I have a particular motion that the defense filed that I haven't write a response to. And I just keep on waiting for it to get better at writing a response. It's still nowhere close to the actual response that I submitted. I have a series of expert reports that I feed to see if it can find the pattern of what's the best plan for cross-examination. And I'm a big believer in that ChatGPT Pro agent. The agent does a lot better than the non-agent at solving complicated things. Like it's actually passed the receipt benchmark, and it did pretty well on James Harris and figuring out, the agent figured out that when he's hired by plaintiff, he says one thing, when he's hired by the defense, he says another thing, whereas other AI foundational models couldn't figure that out.
Interesting.
And I tend to think about the AI world in two parts, by the way. It breaks out pretty nicely. The knowledge part and the rewriting part and the thinking part seems pretty decent right now. But the doing part is generally pretty weak. Like that needs a lot more work. Like it'll say it's doing stuff, but a lot of times it gets it wrong. The agent does a somewhat okay job at doing things now.
Yeah. So here's another topic, and this is going to be the last topic because we've been on. I mean, we could be on all day because you're giving us all sorts of interesting stuff. But this is a conversation I had with one of my friends who was also going through law school at the time. It was just at the end of his law school, the end of his third year, and we were talking about AI and its role in law school. Like, how much should law school be teaching these young lawyers on how to use it in their practice? And my
Well,
position was they should be
yeah.
teaching a class on it for sure.
100%, 100%. I think that it's helpful. The way I would structure it personally, I'd make it a lab. I'd make it a lab because it's a time to experiment and see. And there's an old story called, I think it's the story of John Henry, where it's like John Henry was like the best at laying down railroad. Um, and then like, I don't know, I think I saw a Disney cartoon of this when I was growing up, but then there's like a machine that's laying railroad and they have a race between John Henry and the machine. And John Henry wins the race, but then he lays down his hammer and he dies at the end of it. So, I mean, there's a lesson there. But this is what they ought to be doing in law school: is have the kids, the students, the law students write a brief and have the AI write the brief, and then you compare them. And then feed the brief into the AI and go, how do you make this better? And use it as an experiment, do it as a lab, use it like, hey, this is what the humans are finding, this is what the AI is finding, where is it better and where is it worse? That type of comparison, and then teaching people, how do you make essentially the centaur? It's kind of that. I think I got that term out of like chess, because what's better, a human player or a chess player? The answer is neither. It's actually a human player using a chess computer can do better than either, because it makes I mean, obviously a chess master, but a chess master for like the insight and the computer for the raw power. And you put those things together and make kind of a centaur of a chess player. And I think it's the same way for lawyers. We need to work with these tools, and the best way to learn how to do that is in the context of a lab.
And then how about young kids, not kids, or young adults who are thinking about going to law school and having a career in law? What do you see the future of law by the time they get out and get a job? I mean, how do you see that playing out?
It's a good question. I've spent a lot of time in this space. I think about it a lot, but it's not like I have any kind of crystal ball and know. I'm not concerned just about practicing law. I'm concerned about doing anything. I mean, like, what are humans still going to be better at? The thing that I've been using as my benchmark for what I'm pretty sure the computers aren't going to be better at is comforting a hurt child. I'm pretty sure that's going to be in the domain of the parents. That the day that a computer can comfort a hurt 5-year-old better than a parent can, okay, now I think
We're
all
in
bets are
trouble.
off. But I don't also think that that's impossible. I mean, it's not like parents are always the best at this either. And maybe the computers do it, or the robots do it a billion times and figure out what is the best strategy. And it turns out it's, a candy and an ice pack solves it. But yeah, getting back to lawyers, I don't know. There's a model I call the clash of two worlds. There's the world that I grew up in, and it's the world that my grandparents and my parents and aunts and uncles and stuff lived in. And that's what I always assumed would be there. And then there's this other world, which is that like this AI becomes super intelligent and almost everything that we do in the world changes. And the question is, which one of those is actually going to be there? Recently, I think I figured out a way to harmonize those two things, which I think is the reality, which is as you're going towards like kind of the singularity of this thing becoming super smart, it does end up changing everything, but you always have line of sight as to where it's going. Like it doesn't actually completely blindside you, because the goalposts keep moving. Like it's almost like we're going around a corner, but we can always still see what's in front of us a little ways. So we've become accustomed to the fact that you can just ask an AI a question and it knows what disco song was #1 in 1977 without any problems. Like it just knows everything all the time. And very complicated things, like if I shoot an arrow, like at this feet per minute, like how long is it going to take to hit the ground? Like it can do all the calculations, figure it out super, super well. if I told people that you could get all of this information from just asking a question when I was going to law school, it would be like, what are you smoking? Like, that can't be. That's too much. But we've become accustomed to it. And I think we'll continue to become accustomed to what these computers can do. And I guess to actually answer the question, I don't think lawyers are going away. I just don't. Our jobs may morph quite a bit, but you can see this from some historical things. Like when ATMs came in, they were worried that bank tellers were going to be laid off and there were a bunch of people going to lose jobs. Truth is, there's more bank tellers now than what there were before ATMs. Their jobs just changed. They do a lot more customer service and selling financial products and other things. Radiologists, when the AI came on, they started saying, oh, radiology is going to be the first thing to go because it's going to read MRIs better than a human would, or X-rays better than human. It's true. But there's actually more demand for radiologists, as I understand it, because radiologists are just simply doing more. When they figured out that they could use AI, now there's a whole host of things that radiologists could find that they didn't used to be able to find. And now radiologists are doing much more patient intervention because they have time to do it. I think it's the recognition, like as a lawyer, I've got a bunch of stuff I want to do, but I can never get to the bottom of my list. And the truth is, as a human and as a curious person, my list is endless. As it helps me with some of the stuff at the top of the list, and that's getting done more efficiently, it's just going to free me up to do more and more and more stuff. I'm endless. I'm never going to get to the bottom. I'll just always think of something cool next to do once I get there. And having a legal background, I mean, lawyers are probably the safest possible thing to be because lawyers write the rules. And the day that like the courts approve a trial happening without lawyers there, I don't see it happening. We'll protect ourselves. So you're always going to have a job. But I do think Rick's point that if you are a Luddite, if you just don't believe in this stuff, you run the risk of just being lapped, that you're just going to be left behind. It's almost like, I'm sure when word processors come out, there were lawyers that were like, I prefer the typewriter. You don't see those people around anymore because word processors are just simply better. Lawyers working with AI are just simply better than lawyers working without it. So if that's the plan, I think that's probably destined to fail. But a lawyer who's working with the best technology will always have line of sight as to what's happening next as we go through these rapid changes, and is probably going to be just fine.
I want to end with just if there was ever a book that you've read throughout, your career, or maybe a podcast that you're currently listening to right now that you think is interesting or helpful, either or.
Well, okay, I'm going to pick two books because I go kind of long. You actually turned me on to one, The Untethered Soul. I think that was a great book. I really enjoyed reading that, and it gave me a lot of perspective on I'm still having a human experience and helping me understand my own emotions, my own reactions to things, and helping me attain the center of consciousness where I can see what, stepping back from my emotions and my frailties and so forth, and having some perspective on myself is incredibly helpful. And I think that book is great. I was also really impressed when you're talking about AI, Ray Kurzweil's 2025 book, 2024 book, The Singularity is Nearer, is incredibly insightful. I think if I'm limited to two, I'll pick those two. And in terms of podcasts, I personally like Moonshots. Those guys have drunk the Kool-Aid. They're incredibly positive. They're incredibly optimistic about the future of technology and so forth. But honestly, I get tired of all the negativity about the world. I mean, the truth is, Rick and I are old enough that we remember what it was like earlier. And sometimes people get nostalgic that things were better in the old days. I don't think they were. I really don't think they were. I think they're better now. I think that there's problems. There's always going to be problems in the world, but focusing only on the negativity just wears people down. And I don't want that. I want to be optimistic. I want to make things better. And believing that things can get better is the key to actually making things better. Those guys are incredibly positive and they're probably wrong about some stuff. Okay, so they're wrong. But having a positive attitude means they might be right about some of the stuff as a result. So, and they might actually do something about it because they believe. So that's my recommendation is just, you can't have fear and doubts conquer you. You just need to plow forward and then assume, like, if you're smart and you're talented and you've invested in yourself, if the world changes in really radical ways, well, you'll adjust.
And Sam, if somebody wants to get a hold of you, can you just give us your email and then your website address as well?
Yeah. So my email is sam@samelderlaw.com and my website is samelderlaw.com.
Thank you. I appreciate all your time, all your wisdom, and your, positivity, man. That was just great. Thank you so much for joining us. And it was supposed to be only 45 minutes, but it ended up an hour and a half because you just had so many great things to say. So thank you.
Well,
So
sorry
good
if
to
I
have
went too
you.
long, and thanks for having me on.